Thank you, Mr. Chairman. I just have a few questions. Ms. Westerkamp, are you familiar with the term Performance Improvement Plan, sometimes referred to as a PIP?
Yes.
Would you agree that employees subject to a PIP are essentially being notified that some aspect of their performance is unacceptable?
Yes.
Have you ever been subject to a performance improvement plan in your time at the Department of Justice?
No, sir. Senator, I've received excellent ratings.
So there's never been any issue your superiors or supervisors have had that required anything like a performance improvement plan?
No, Senator.
Lane, I wanted to ask you about your experience trying cases. Have you ever tried a case to a verdict before a jury?
Senator, I've worked on a bench trial, and as a federal law clerk, I handled 7 trials.
The legal empire that Donald Trump has built around himself, the army of loyalists and true believers he installed to shield him from accountability, is being dismantled piece by the very people who swore to uphold the law. What we're about to show you is a portrait of a legal defense in freefall. A federal judge has just delivered what can only be described as a judicial sledgehammer to the Trump-aligned prosecutors running a United States Attorney's office. The ruling didn't just criticize, it annihilated.
I was a federal law clerk as well. I wouldn't say that I handled the trials. I think the judge handled the trials. Have you ever been subject to a performance improvement plan in your time at the Department of Justice?
No, sir. Senator, I've received excellent ratings.
So there's never been any issue your superiors or supervisors have had that required anything like a performance improvement plan?
No, Senator.
Have you ever been subject to a performance improvement plan in your time at the Department of Justice?
No, sir. Senator, I've received excellent ratings.
So there's never been any issue your superiors or supervisors have had that required anything like a performance improvement plan?
No, Senator.
It declared that key appointments at the Justice Department were unlawful from the very beginning. And the judge didn't stop there. He issued a warning that sent shockwaves through the Department of Justice. If the Trump administration keeps using these unlawful appointments, criminal cases could be thrown out entirely. That means people the government is prosecuting could walk free. Not because they're innocent, but because the prosecutors had no legal authority to bring charges in the first place.
Bench trial. Were you the lead counsel in that case?
No, Senator, I was part of a small team of attorneys.
Were you the senior or associate counsel on the case?
Yes, Senator, I was an associate on the case. There were 4 attorneys on the case. I was responsible for helping prepare witnesses, helping second chair depositions. I also took a deposition myself. I cross-examined a witness at trial, and I was responsible for all the pretrial and post-trial briefing, findings of facts, conclusions of law.
And of the 4 attorneys, how many were more senior to you on that team?
And this is just one front in a multi-front collapse. In New York, judges overseeing Trump's criminal and civil proceedings have been scolding his personal attorneys in open court, rebuking them for arguments so weak that they seem designed more for cable news segments than actual legal proceedings. In one case, a lawyer tried raising a defense that the judge had already explicitly barred. In another, a federal judge sanctioned Trump's attorneys personally, ordering them to pay monetary penalties.
Senator, I believe 2. There were several people who came in to assist, but again, my responsibilities, I was the primary drafter for all the briefing.
No, I heard that. I just want to understand. So your trial experience consists of being the second or third senior lawyer on a bench trial?
Senator, yes, it was a week-long trial involving complicated constitutional issues, and my role, again, was I helped draft and prepare all the briefing.
But you've never done jury selection, never done voir dire, for example.
And wrote in his ruling that no reasonable lawyer would have ever filed that lawsuit. No reasonable lawyer. That's not a difference of opinion. That's a federal judge saying, in writing, that the people representing Donald Trump violated the most basic professional standards of the legal profession. Together, these rulings paint a picture of chaos, incompetence, and a legal strategy that prioritizes loyalty over competence, political theater over legal merit.
When I was a law clerk, Senator, 5 of the trials before the judge who I clerked for were jury trials, and so I had the opportunity.
And I was a law clerk. It was a great experience, but I didn't pick the jury when I was a law clerk. I didn't question the jurors. I didn't seek to use a peremptory or other challenge for cause for a juror. That's really not the role of a law clerk. You observe it, but you don't do it yourself. And so have you, apart from the bench trial, have you cross-examined witnesses in any kind?
At the exact moment, Trump needs a functioning legal apparatus more than ever. He's facing criminal prosecutions, civil fraud judgments, contempt proceedings, and the kind of political pressure that would crush any other figure in American politics. And yet, the lawyers he surrounds himself with are being publicly humiliated by judges, and the prosecutors he installed are being stripped of their authority. This is not a drill. This is the collapse of a legal operation under judicial scrutiny. Let's start with New Jersey, where a federal judge looked at the 3-person leadership team running the U.S. Attorney's Office and ruled that they were unlawfully installed. Now, to understand why this matters, you have to understand how federal prosecutors are supposed to get their jobs. The Constitution's Appointments Clause and federal statutes lay out a clear process. U.S. attorneys require Senate confirmation. Temporary or acting appointments are governed by the Federal Vacancies Reform Act, which sets strict rules about who can serve in those roles and for how long. The judge found that Trump's team violated these requirements. And the language the judge used wasn't the polite, technical language judges often use when they find a procedural error. This was sharp criticism, the kind that signals a judge believes someone deliberately circumvented the law. Deliberately circumvented. That means the judge didn't just find a mistake. The judge found a pattern of behavior designed to bypass the Senate's constitutional role, to install loyalists quickly without hearings, without confirmation, without the checks and balances that the founders put in place to prevent exactly this kind of power grab. And here's where it gets even more dangerous for the Trump administration. The judge warned that if the administration keeps using these unlawful appointments, he may dismiss pending prosecutions. That's extraordinary. Judges almost always prefer to decide cases on the merits, on the evidence, on the law, rather than dismissing cases on procedural grounds. When a judge threatens to dismiss cases because the prosecutors themselves lack authority, it tells you everything you need to know about how serious the judge views the violation. Think about what that means. Every single case those prosecutors brought, every investigation they conducted, every charge they filed, all of it is now vulnerable. Defense attorneys across New Jersey are likely already filing motions to dismiss, arguing that their clients are being prosecuted by people who had no legal right to be there in the first place. And some of those motions will succeed. That means people Trump wanted prosecuted, people his Justice Department targeted, could go free. Not because the evidence against them wasn't strong, not because they were innocent, but because the prosecutors who brought the cases weren't legally authorized to do so. That outcome is directly attributable to Trump's decision to prioritize loyalty over legal compliance when he installed his leadership team. Now let's shift to New York, where the story is equally grim for Trump's legal operation. In the hush money criminal case and the civil fraud proceedings, judges have repeatedly scolded Trump's lawyers in open court. This isn't behind closed doors. This is on the record, in front of reporters, in front of the public. In one instance, a judge rebuked a Trump attorney for trying to raise a defense that the judge had already explicitly barred. The judge had ruled that this particular line of argument couldn't be brought at trial. The lawyer tried to bring it anyway. Either that lawyer didn't understand the judge's ruling, which suggests incompetence, or the lawyer deliberately violated the ruling to create an issue for appeal, which suggests bad faith. Either way, it's not the kind of lawyering that inspires confidence when you're facing potential prison time. And it's not a one-time thing. The pattern of improper arguments, of lawyers making speaking objections that are really just arguments, of being unprepared to question witnesses, of making factual assertions without any evidentiary support. These are basic professional lapses. These are the kinds of things that law students are taught not to do. And yet, this is the team Trump is relying on as he faces the most serious legal jeopardy of his life. But the most humiliating moment for Trump's legal team came in a separate case entirely. Judge Donald Middlebrook sanctioned Trump's lawyers, including Peter Ticktin, over a lawsuit they filed against Hillary Clinton and others, alleging a massive conspiracy to fabricate the Russia collusion allegations. The suit sought millions of dollars in damages, but Judge Middlebrook found it had no factual or legal basis. And he didn't just dismiss it, he eviscerated it. In his ruling, the judge wrote that no reasonable lawyer would have filed that lawsuit. No, reasonable lawyer. That is devastating professional criticism. The no reasonable lawyer standard is used in sanctions motions to determine whether an attorney's conduct falls below the minimum professional standards. When a federal judge concludes that no reasonable lawyer would have filed a case, that judge is saying the case was so frivolous, so lacking in merit, that filing it violated Rule 11 of the Federal Rules of Civil Procedure, which requires lawyers to have a reasonable basis in fact and law for the claims they bring. But the judge didn't stop there. He ordered monetary sanctions. That means the lawyers themselves had to pay penalties out of their own pockets. Not their clients, not their insurance, their own money. That's a punishment reserved for egregious misconduct, designed to deter lawyers from filing frivolous cases in the future. And Judge Middlebrook said something else that cuts to the heart of what's happening with Trump's entire legal strategy. He said courts aren't for performative litigation. Performative litigation. That's a term that's been used to describe lawsuits that are filed not to resolve a genuine legal dispute, but to create a spectacle, to generate headlines, to energize a political base, to use the courtroom as a stage for political theater rather than a forum for justice. Judges resent performative litigation because it wastes judicial resources. It clogs dockets with cases that have no merit. It forces courts to spend time and energy on claims that never should have been filed in the first place. And it undermines the integrity of the judicial system. This pattern of performative litigation isn't new. After the 2020 election, Trump's lawyers filed dozens of lawsuits challenging the results. Courts rejected virtually all of them, many with harsh criticism of the legal theories and factual allegations. Some of those lawyers faced sanctions or disciplinary proceedings. The Clinton conspiracy suit followed the same pattern. Legally baseless, politically motivated, filed to generate headlines rather than win in court. Now let's connect the dots between the unlawful prosecutor ruling and the broader concerns about how Trump uses the Justice Department. The Department of Justice is part of the executive branch, but it has a long tradition of independence from the White House when it comes to law enforcement decisions. That independence is supposed to protect the DOJ from being used for the president's personal political benefit or against his political enemies. Trump has repeatedly attacked that independence, claiming that he should have control over who gets prosecuted and who doesn't. When he installs loyalists without going through the proper appointment process, he's finding a way around those independence norms. If he can't get the Senate to confirm partisan prosecutors who will do his bidding, he appoints them temporarily, bypassing Senate scrutiny. These temporary appointees know they serve at Trump's pleasure. They owe their jobs to his willingness to bend the rules. And that creates loyalty to Trump over loyalty to the law or the Constitution. And judges are now saying that breaks the rules. That's not a partisan opinion. That's a judicial finding. Civil libertarians and legal experts have warned for years about the dangers of a politicized Department of Justice. Now a federal judge has confirmed those warnings, finding that Trump's appointments violated federal law and the Constitution. That judicial validation gives legitimacy to concerns that might otherwise be dismissed as partisan attacks. And it raises a terrifying question about the future. If Trump is willing to install unlawful prosecutors now, what will he be willing to do during a future election? During a crisis? The precedent of a judge finding these appointments unlawful doesn't stop Trump if he's willing to defy the courts. This is how democratic institutions erode, not with a single catastrophic event, but with a slow accumulation of norm violations, of rule bending, of testing the limits until the limits no longer hold. Now consider the timing of all this. Trump is facing criminal prosecutions in multiple jurisdictions. He's facing a massive civil fraud judgment that threatens his business empire. He's facing contempt proceedings. And on top of all that, he's dealing with the political pressure of a volatile international situation. This is the moment when he needs a competent legal team. Experienced lawyers who know the rules, who judges respect, who can navigate complex proceedings while maintaining credibility. Instead, he has lawyers who judges are sanctioning and mocking. He has prosecutors who judges are declaring lacked legal authority. And those two problems are hitting simultaneously, multiplying his legal risks in ways that are hard to overstate. When judges don't respect your lawyers, they're less likely to give you the benefit of the doubt on close calls. When prosecutors lack authority, your ability to use the Justice Department to protect yourself or attack your enemies is compromised. And when both problems are happening at the same time, it creates vulnerabilities that even the most politically connected defendant can't afford. This matters because legal proceedings are partly about credibility. Judges and juries assess the credibility of witnesses, of attorneys, of the parties themselves when they make decisions. Trump's credibility is already damaged by a history of false statements, of findings of fraud, of conduct that courts have described as deceptive. And when his lawyers are publicly humiliated by judges, when judges say they're making frivolous arguments, when judges sanction them personally, that further damages his credibility. It makes adverse outcomes more likely. And it matters politically, too. Trump's political power rests partly on an image of strength, of being a tough, smart leader who surrounds himself with the best people. He's the guy who says he knows more than the generals, more than the doctors, more than anyone. But when federal judges are calling his lawyers unreasonable and his prosecutors unlawful, that image takes a hit. Supporters who believe in the strongman narrative may start to question whether the people around him really are the best, or whether they're just the most loyal, whether loyalty has been prioritized over competence to the point where the entire operation is falling apart. A federal judge in New Jersey ruled that Trump's three-person leadership team running a U.S. attorney's office was unlawfully installed. The judge sharply criticized the appointment process and warned that if the administration keeps using these unlawful appointments, pending prosecutions could be dismissed. That means criminal cases could collapse because the prosecutors lacked authority. Judges in New York have repeatedly scolded Trump's lawyers in the hush money and fraud proceedings. They've rebuked attorneys for trying to raise defenses that were already barred. They've called out patterns of improper arguments that show systematic problems with preparation and strategy. Judge Middlebrook sanctioned Trump's lawyers in the Clinton conspiracy suit, writing that no reasonable lawyer would have filed it and ordering them to pay monetary sanctions out of their own pockets. The judge in that case said courts aren't for performative litigation, a damning assessment that Trump's legal team is using the courts for political theater rather than genuine legal disputes. The Federal Vacancies Reform Act governs temporary appointments, and Trump apparently violated those requirements. His appointments were void from the start, meaning the prosecutors lacked authority to act in their official capacities. The sharp criticism from the judge suggests Trump deliberately circumvented the law to install loyalists without Senate scrutiny, a more serious finding than an inadvertent procedural error, showing potential bad faith. The threat to dismiss pending prosecutions shows the judge views these appointment violations as fundamental defects that can't be overlooked. Defendants might go free regardless of the evidence because the prosecutors lacked standing to bring charges in the first place. The pattern of Trump's lawyers making improper arguments in New York shows an overmatched legal team, one that's unprepared to question witnesses, that makes assertions without evidentiary support, that commits basic professional lapses. The no reasonable lawyer standard is the legal profession's way of saying that conduct fell below minimum professional standards. When a judge concludes that standard was violated, it's a serious professional rebuke. Personal financial sanctions, penalties that come from the lawyer's own pockets, are designed to deter frivolous filings. The judge imposing them shows he believed deterrence was necessary because the conduct was egregious. Installing loyalists without proper process circumvents the DOJ's independence norms. Temporary appointees serve at Trump's pleasure and owe their jobs to rule bending, creating loyalty to Trump over loyalty to the law. Judges finding these appointments unlawful validates the concerns of legal experts who have warned about the dangers of a politicized Justice Department. It gives judicial legitimacy to warnings that might otherwise be dismissed as partisan. The timing of these judicial rebukes, while Trump faces criminal prosecutions, civil judgments, contempt proceedings, and political pressure, creates compounding vulnerabilities. The damage to his credibility makes adverse outcomes more likely. The gap between Trump's strongman image and the reality of his legal operation, sloppy, politicized, getting torn apart in real courtrooms. exposes a fundamental vulnerability. When judges don't respect your lawyers, when prosecutors lack authority, your ability to defend yourself is compromised. What the legal system needs is professional, competent attorneys who respect judicial authority and constitutional process, not performative litigators filing frivolous cases for political theater, not unlawfully installed prosecutors serving political interests over the rule of law. And that's the bottom line. The legal operation that was supposed to protect Trump is being dismantled by the very judges who were supposed to be neutral arbiters of the law. They're not political enemies. They're not activists. They're federal judges who are looking at the conduct of Trump's lawyers and prosecutors and finding that it falls so far below professional standards that they have to step in and stop it. That's not a partisan attack. That's a judicial system doing its job. And for Trump, that's the most dangerous development of all.